First, when in any warrant case instituted otherwise done than a police report, but this is a case that is instituted a warrant procedure otherwise done in a police report, it leaves no doubt. The accused appears and is brought before the magistrate. The magistrate shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution. Kindly pause for a minute. Well, the law enjoins a duty, be it upon the court or be it upon the complainant, my lord, to produce all such evidence. I'm sure your lordship would certainly agree with me. The trial judge says it is only the examination chief is evidence and cross-examination and re-examination is not evidence. I'm sure your lordship would certainly agree with me. The evidence that is found under section 244 is not confined only to examination in chief. It certainly includes cross-examination and re-examination. Let me repeat it. The risk of repetition requires that accused appears or is brought before them. The magistrate shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution. Here the prosecution is the private party, a complainant has got a lead evidence. The magistrate may, on the application of the prosecution, issue summons. But here even summons could also be issued to the witnesses, to any of the witnesses, directing him to attend or to produce any document or thing. If upon taking all the evidence referred to in section 244, but even under section 244, your lordship would get or take all such evidence. Now under 245 also, if upon taking all such evidence referred to in section 244, the magistrate considers for reasons to be recorded that no case against the accused has been made out, which if unrebutted would warrant his conviction, the magistrate shall discharge him. But the evidence that is laid under section 244, where it is only examination in chief or cross-examination and the re-examination, if it were to remain intact on record in the case without being subjected to the test of cross-examination, the magistrate should be in a position to give a finding. Well, that is sufficient to hold the accused guilty.
Now, what has the court done?
I'm sorry, my lord.
What has the court done now?
Court says it is only examination in chief alone that could be looked into.
So, you filed an application for compliance with 244?
No, my lord, I have cross-examined the witnesses.
Oh, you already cross-examined?
Yes. My lord, next only one sentence, then I shall take your lordship
Yes.
to the finding that is given, and then the law laid down by the Supreme Court. Well, now kindly go to 245, my lord.
Yes.
Leave the evidence led by the complainant in the absence of a touchstone method of that evidence being subjected to the test of cross-examination.
Yes.
If that were to be left alone, unrebutted, without being tested, subjected to the test of cross-examination, that should infuse a confidence in the judicial mind of the court that is sufficient to hold the accused guilty. Otherwise, no, my lord, he can't do it. Under section 245, my lord, then, my lord, comes 246. If when such evidence has been taken, here also your lordship would get evidence, 245 evidence, 246 evidence, 244 also evidence has been taken, or at any previous stage of the case, the magistrate is of the opinion that there is ground for presuming that the accused has committed an offense triable under this chapter, which such magistrate is competent to try and which in his opinion could adequately be, he shall frame the charges in writing. So the basic essential requirement for the court
How
is
is it? It is at the stage of framing of charge. No, it is crossed that.
no, my lord, I would make an application requesting the learned judge to exercise his jurisdiction under section 245, no sooner the evidence is recorded, to pass an order of discharge in my favor. May I invite your lordship's kind attention to the order, my lord, without going into the evidence. I don't want to take your lordship to the evidence at this point of time. If it becomes necessary, certainly I shall do it. May I invite your lordship's kind attention to the order at page 100, commencing from page 178. Kindly go to page 178.
Yes, sir.
I think it would be useful for me to invite my lord's kind attention straight away. the finding which my lord gets at page 186 first, then I will go back. My lord, with all humbleness, let me submit to your lordship. This judge thinks that he knows better law than his predecessor in office. He writes it. He writes it. But may I request your lordship to kindly go to page 186, para 22. As already discussed here in above, after the evidence of prosecution under section 244 of CRPC, the stage is for charge or discharge of the accused under section 245 of CRPC. It is thereafter, my lord may kindly note this, it is thereafter the accused gets the choice of cross-examination of complainant and the prosecution and its witnesses. However, maybe due to inadvertence, in this case, my predecessor in office had allowed the accused to cross-examine PW1 prematurely before the charge, before the stage of under section 245 of CRPC. As such, that portion of premature cross-examination of PW1 by the accused cannot be considered at this stage of section 245(1) of CRPC. Because if such cross-examination of PW1 is also considered at this stage, it would amount to final appreciation of evidence for arriving at a final conclusion, and that would lead to the judgment of conviction or acquittal. But this is certainly unacceptable. It is an assault on the provision of.
Yes, what are the judgments?
I'm sorry, man.
Judgments.
Any number of judgments I shall. Still, if my lord feels.
Yeah.
ಅಲ್ಲಲ್ಲ ಇವ್ರು ಬರೆದಿರೋದೆಲ್ಲ ಫೈಂಡಿಂಗ್ಸ್ ಎಲ್ಲ ಎಲ್ಲ ತಪ್ಪ ಫೈಂಡಿಂಗ್ಸ್ ಎಲ್ಲ ಬರ್ದಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ. That is number one. But kindly go to the second issue, legal issue that is involved in the case is this. But probably to buttress his claim, the complainant would send certain documents to the private forensic science laboratory. That is
Private laboratory?
Truth.
Truth labs.
Truth labs. ಅದರಲ್ಲೂ ಏನಿತ್ತು ಹೇಳ್ಬಿಡ್ತೀನಿ, ಮುಂದೆ ನಿಮಿಷ ಹೇಳ್ಬಿಡ್ತೀನಿ, ಜಾಸ್ತಿ ತಗೊಳ್ಳಲ್ಲ. Well, the truth lab would give a report. May be or may not be in favor of the complainant. Let us not go to that report now. But what came to be sent to the laboratory for the purpose of comparison? Well, it is crystal clear that in the science of handwriting, my lord, what is needed to be sent to the expert for comparison and his opinion are threefolded. Number one, question document or a disputed document. In common parlance, we call it as disputed document. Well, scientifically, they call it as question document. Number two, standard writings or standard signatures. Writing or a signature which has come into existence at an undisputed point of time. Number three, a specimen writing or a specimen signature. These are the basic documents that are needed for the purpose of comparison of a writing or a signature by an expert. It is only thereafter, my lord, by using some technical devices and all that, he has got to compare the writings and signatures vis-a-vis the question document and then give his opinion. But what came to be sent to the truth lab are all Xerox copies of the documents. That is impermissible.
Where do you get that?
Yes, I shall take your lordship now to that. And what the learned judge says is, does not matter whether it is a original or a Xerox, he has given opinion. And he is not even examined. And under 244, all such evidence, marking of a report through the complainant who has nothing to do with that document, cannot be read in evidence. May I now invite your lordship's kind attention to kindly go to page 176 at paragraph 13. 13.
170?
176, 176 at paragraph 13. Well, I'm only on two important legal issues. It is only for that limited purpose I'm drawing my lord's kind attention. Para 13. That apart, the complainant has also got compared and examined the signature of the accused number one. Exhibit P6 through an expert of the Truth Labs, Bengaluru, and obtained the report as per Exhibit P22. On considering all the above documents with the testimony of PW1, prima facie it appears that there is such a difference in signature of accused number 1 in Exhibit P6 and other documents which could be noticed with naked eyes by any prudent man. Similarly, there appears to be some similarities in the nature of signature of accused number 1 in Exhibit P6 and the signature of accused number 2 in Exhibit P9. Therefore, the documentary evidence produced by the complainant in his examination in chief prima facie corroborate the allegations of complainant as to the forgery of signature of accused number 1 in Exhibit P6, though the said documents are subject to test and proof by way of cross-examination by the defense counsel. Now, my lord, kindly go to page, because your lordship asked me a question about the Xerox copies having been sent. Where do we get it? Kindly go to paragraph 180, paragraph 17, page 180, paragraph 17. Further, as rightly argued by the learned senior counsel for submission, well, finding is in my favor, but the result is against me, unfortunately. Further, as rightly argued by the learned senior counsel for submission of the said form number 6, the personal presence of the accused number 1 was not mandatory. No doubt, such a form of a person could be submitted by any of the agents or workers, but such form should prepare and signed by the accused number 1 himself, but not anybody else. As such, in the present case also, there was no bar for the accused number 2 to submit the said form number 6 of the accused number 1 to the electoral registration officer. Said form number 6 should have been duly signed by the accused number 1 himself. It is the allegation of the complainant that the same was signed by the accused number 2, as if it was signed by accused number 1, who was not at all in India at that particular point of time. Therefore, the issue as to the forgery of signature of accused number 1 by accused number 2 is for trial in this case, but not the issue as to the filing of submitting the form number 6, etc. Then, my lord, he also admitted down below, etc. Probably we can skip all those things and then kindly go to straight away.
But this line of argument cannot be considered at this stage.
He can't consider it. He said, my lord, I shall just show to your lordship. Kindly go to page 189, paragraph 25. This here your lordship would get it. Because this would clear your lordship's question to me. Paragraph 25. No doubt on perusal of the records, it appears true that the complainant for getting the said expert opinion in Exhibit P6 had not supplied the originals of the said form number 6 and also not supplied specimen signatures of accused number 1. But he has supplied Xerox copies of the said Exhibit P6 to the said truth labs along with the documents containing standard/admitted signatures of accused number 1. On the basis of the same, the expert of the said lab has given his opinion as per Exhibit P22. Whether the said opinion could be accepted or not could be considered only upon his examination, which he has not done. He places reliance on that, says it is a case of forgery. Opinion on the basis of the said Xerox copy of Exhibit P6. Moreover, any such expert opinion or scientific report may not be a sole and substantive evidence to decide the issue in this case. It may be one of the corroborative piece of evidence. Well, what was sent to the expert, that is the truth lab, for opinion, examination and opinion, are 3 Xerox copies of the documents, and on the strength of those 3 Xerox copies of documents, not even the specimen signature, well, the opinion came to be given. And even otherwise, well, the expert having not been examined under section 245, the learned magistrate ought not to have placed reliance on the opinion that is marked through the complainant who has nothing to do with this. Now, straight away, let me invite my lords. I have many more points, but this is sufficient for me at this point of time, would be my respectful submission.
Yes, Abram. Only these legal submissions.
One more minute.
Oh, no, yeah.
One more. In fact, the Supreme Court has come upon this truth lab heavily.
Truth labs.
ಅದರಲ್ಲಿ ರೆಫರ್ ಮಾಡಿದೆ. untrustworthy, dishonest. Let me invite my lord's kind attention to first judgment of the Supreme Court, my lord, on the point. My lord, even in law college also we are taught, my lord, evidence means examination in chief, cross-examination and re-examination. And I invited my lord's kind attention to the finding given by the learned
25.
magistrate. Only examination in chief. No, I can't look into it. My predecessor in office has
No,
committed a
the
serious.
basic thing is, if something has to be considered for the purpose of discharge, it cannot be only on one side's evidence.
Well, that is what the Supreme Court has said.
That is what I know.
Straight away, let me invite your lordship's attention to the judgment of the Supreme Court, 2013. ಕೊಡಿ. ಅವ್ರಿಗೂ ಕೊಡಿ.
Copy ಅವರು ಕೊಡಿ.
ಕೊಡಿ, ಅವ್ರಿಗೂ ಒಂದು ಕೊಡಿ.
ಕೊಟ್ಟಿದ್ದೀರಾ?